Most people who are considering hiring a Wisconsin personal injury lawyer have the same question. How does the lawyer get paid? It's an important question. So in this video, I'm going to explain clearly how contingency fees work in Wisconsin personal injury cases. I'm Craig Steger, and I'm a personal injury attorney in La Crosse, Wisconsin. So what is a contingency fee? In Wisconsin, most personal injury cases are handled on what's called a contingency fee. A contingency fee means that there's no upfront attorney fee. The lawyer is simply paid on a percentage of the recovery at the end of the case. If there is no recovery, there is generally no attorney fee. A recovery is simply a payment of money, either through a settlement or maybe after a trial verdict. The fee is contingent, meaning it depends on a successful outcome. You should be given a written fee agreement to review and sign, and it should set forth the terms of the contingency fee agreement. So how does it work in practice? You see, if a case resolves through settlement or verdict, the recovery is distributed according to the written fee agreement. The attorney receives a percentage of the recovery as the fee. In most personal injury cases, the percentage the lawyer received is between 33 and 45%, but each case and each lawyer may vary. Sometimes the contingency fee agreement works in stages, so if a case settles before suit, it might be one percentage. If it requires an appeal, which often means a new trial is necessary, the percentage may increase. This will be laid out clearly in your written contract with your lawyer. The client receives the remaining portion after attorney's fees, case expenses, and any required liens are satisfied. So what's a lien? A lien may be a hospital lien for medical expenses, or what we call a subrogation lien, which is if another insurance company, such as your health insurance company, if they paid some of your damages or expenses, they may be entitled to reimbursement from your recovery. The exact percentage and structure should be clearly outlined in writing before you sign anything. You should make sure you understand it and ask questions if you're confused. You should feel comfortable with it. If you're uncomfortable, ask questions or maybe talk to another attorney. Consultations with personal injury lawyers are almost always free. Now, why do we have contingency fee agreements anyway? Well, there's a reason this structure developed in personal injury law. You see, people who have been injured are often dealing with medical expenses. They may be out of work. They have financial stress. Most people are simply not in a position to pay hourly legal fees while also recovering from an injury. Insurance companies don't usually pay right away. Usually there's one payment made and not until way at the end of the case. Contingency fees protect people from insurance companies who want to delay settlement as long as they can. A contingency structure allows someone to pursue a claim without paying upfront attorney's fees. It also provides incentives to the lawyer to get the best possible recovery and to complete the case as soon as possible. A contingency fee also protects the client if, unfortunately, the case is unsuccessful. A contingency fee arrangement is generally a win-win situation for the client and the lawyer. Now, what happens if there is no recovery? In most contingency agreements, if there is no recovery, there is no attorney fee owed. That is different from an hourly arrangement where you would generally pay the attorney for their work regardless of the outcome. However, one thing you need to ask if you're responsible for case expenses occurred on your case. I'll talk more about case expenses in a moment, but in some contingency fee agreements, you are still responsible for those expenses even if the case is unsuccessful. In others, the attorney simply waives those expenses. So be sure to review your fee agreement with your lawyer. Every lawyer's fee agreement should be clear about how fees and expenses are handled if a case is unsuccessful, and make sure you ask any questions you might have of that lawyer. Now, one area where confusion sometimes occurs is the difference between attorney's fees and case costs. They're not the same thing. Attorney's fees are the percentage paid for the legal representation itself. Case costs are expenses required to develop and pursue your case. That includes things like copy charges for medical records, court filing fees, expert witness retainers, deposition transcripts, and court reporter fees. Now, in most cases, the lawyer will simply advance or pay for those costs out of their own pocket during the case and then simply get reimbursed for those out of the recovery. In other words, If there's a settlement, the lawyer will be paid a percentage of that total as their fee and then be reimbursed for case expenses out of the remainder before any liens are paid. The client then receives the balance. But again, that structure should be explained clearly in any written fee agreement. It's reasonable to ask your lawyer how expenses are handled. Now, do fees change if a lawsuit is filed? Some people ask whether the percentage changes if a lawsuit becomes necessary. In some agreements, the percentage may differ depending on whether a lawsuit is required. That's because cases that require filing a lawsuit, depositions, expert testimony, and trial preparation involve significantly more time and expense. The key is that this should be clearly explained at the beginning. You should understand what the percentage is, whether it changes, and under what circumstances. Now, I want to address some common misunderstandings that people may have about contingency fees. One is that the lawyer takes most of the settlement. Another is that fees are hidden or unpredictable. A properly structured contingency agreement should be clear. You should know the percentage, and it should also be fair. A lawyer is ethically required to make sure that that contingency fee they charge is fair under the circumstances. A higher percentage generally reflects the fact that your case involves more complicated issues, has a higher risk of losing, or maybe both. You should understand how expenses are handled, and you should receive a breakdown of how funds are distributed at the very end of the case. Now, there may be situations where a contingency fee doesn't actually make sense. If damages are minimal or liability is unclear, a contingency arrangement may not be practical. It may not be something the lawyer can do. Some matters may be resolved directly with an insurance company without a lawyer's help. Some types of cases actually can't use a contingency fee agreements, like divorce and criminal law. An honest evaluation should include whether hiring a lawyer makes financial sense in your specific situation. Sometimes I tell clients not to hire me because it wouldn't be worth it for them. Not every case is the same. Now, there are some questions you should always ask. If you're considering hiring a personal injury lawyer in Wisconsin, here are some questions. What percentage do you charge? Does the percentage change if a lawsuit is filed? How are case expenses handled? What happens if there's no recovery? How are medical liens addressed? A lawyer who handles injury cases regularly should be very comfortable answering those questions clearly, and the written contract should spell this out in no uncertain terms. Contingency fees are designed to make legal representation accessible during difficult times. They allow someone who's been injured to pursue a claim without worrying about paying upfront attorney's fees. Before signing anything, you should understand the structure, the percentage, and how expenses are handled. If you'd like to understand what it's actually like to hire and work with a personal injury lawyer in Wisconsin, you can watch that video next. Or if you're wondering how long an injury case typically takes, you can watch that video as well. Take your time, ask questions, and make informed decisions.